If there will be need for more time, we will consider as and when. And then any party in support of the application for interim reliefs will have 5 minutes each. Respondents, who are the applicants in the applications to set aside, will each have 10 minutes. And those in support will have 5 minutes. And then the applicants will have 10 minutes each in rejoinder. Interested parties, will give them 5 minutes each. And if Senior Counsel Mr. Dr. Amino is around, we will consider his plea.
My Lord,
my Lord, if I may pray, that in view of your directions in regard to the contempt application, we would like it placed on record. In view of the holding in the Supreme Court case of Republic versus Ahmad, Abolathi Mohammed and another, that any application for contempt, just like a preliminary objection, should be had before any other matters. In view of that holding, my lords, we would like that placed on record that you have decided that we hear the potential contemners before the court in the face of that contempt application.
My Lord, I think the court has given a direction, and our position on that is that if counsel is unhappy with the directions you've just given, he knows what to do. We have spent far too much time running away from the business of the day. This matter was certified urgent several days ago. It seems on the 9th of October that when the applications before you was certified urgent, we came here, the other side scattered the date when we came with what turned out to be a frivolous issues about to empanelment. When sufficient time had been wasted on that, they came again with what turned out to be a frivolous application on recusal. Now you're being told about the application for contempt. We must take it as beyond argument that when this application came before the court in Gachagua'S, whereas the court in Gachagua'S fixed a date for the application now before you, it did not fix a date for the application now you're being told to jump the queue. And if that be the case, then we must take it. It did not impress the court in Kirinyaga as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were to hold, my Lord, we too, the party representatives, filed a PO, and you've not heard me telling you that that PO should start. I'm just following the directions being given by the court. And when all is said and done, my Lord, the Swahili say, akili ni nywele, kila mtu akona zake. Nobody needs a brain in this court to know that the reason for all these dilatory tactics is because this side believes, having obtained a final ex parte order, they can now grind the wheels and backpedal and buy time until the conversion of the Jews, or until, as my people say, donkeys grow horns. The court must rein in these tactics.
My Lord, permit me, please, to object to the term frivolous. We have been raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senior Counsel.
My Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Mrima. And my Lord, the comments that have been made by my senior, Dr. Muthomi Thiankolu. My Lord, indeed, there is a preliminary objection that we were served by counsel representing Professor Kithure Kindiki, a PU. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Mrima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction or the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter or business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and two others.
Thank you.
Thank you.
Thank you very much.
My Lord, is it possible that we just proceed?
We
Frivolous is
just Counsel, we don't use that kind of language. I think Senior Counsel Paul Mutes fight that frivolous proceedings are not in this court. They may be elsewhere, but not here. My Lord Justice Mrima will give directions.
We proceed as a directed. Applicants.
My Lord, I was on my feet. This is on behalf